Our top story at 6, the Georgia Supreme Court ruled if you're charged with driving under the influence and refuse a roadside breathalyzer test, prosecutors can't use that against you in a trial.
Chelsea Bimeford joins us in studio to break down what we know about the ruling and what it means for drivers.
Yeah, Frank and Lori, the ruling stems from a 2015 DUI case in Athens-Clarke County where police arrested a woman who refused to take a breath test. Her lawyer argued that using that as evidence against her violates her rights against self-incrimination, which is guaranteed under the Georgia Constitution. Today, the state's high court agreed. Now, police and prosecutors are tasked with still protecting public safety.
Even in the modern day age of Lyft and Uber, thousands of people across the U.S. are still charged with driving under the influence every year. On Monday, Georgia Supreme Court released a new ruling that will change how DUI cases are prosecuted in Georgia.
When this came down, I thought, you know, this is wonderful.
That's Macon DUI defense attorney Ann Parman.
I think it's a correct stating of the law. It's the protection against self-incrimination, and that is so important in criminal law and in DUI law.
Current Georgia law says that when an officer pulls over a suspected drunk driver, the driver must submit to chemical tests of blood, breath, urine, or other bodily substances. If they refuse, their license will be suspended for at least a year, and prosecutors may use their refusal to take the tests as evidence at trial. The High Court ruled that last line is what's unconstitutional.
A court or law enforcement cannot violate your protection against self-incrimination. And I just think that's a cornerstone, or one of the cornerstones, of the United States Constitution and the Georgia Constitution.
This opinion is not a free pass for the motoring public to just say, okay, we can beat it now.
Lieutenant Scott Davis with the Bibb County Sheriff's Office Traffic Division says the change won't stop officers from pulling over suspected drunk drivers.
We're going to enforce the DUI law because the DUI law is still on the books. It's against the law to drive impaired.
By email, Bibb County Solicitor General Rebecca Grice says she expects lawmakers will change state law or the state constitution due to the new ruling.
It is actually finding unconstitutional part of the Georgia DUI law under the Georgia Constitution. So I believe they're going to have to go back to the drawing board and rewrite it.
The judge's decision released today acknowledged that their ruling may make it harder to prosecute driving under the influence, but that they had to respect the constitutional right against self-incrimination. Frank and Lori, back to you guys at the desk.
All right, thank you, Chelsea. The opinion applies only to a driver's breath test, not blood tests. It also says refusal to take the breathalyzer cannot be used in criminal proceedings, but can be used to suspend the driver's license.
To read more about the state Supreme Court opinion, visit our website, 13WMAZ.com.